Okay, while opening the account in the name of general customers, and while opening the account in the name of special type of customers, what precautions the banker is generally bound to undertake. If he doesn't, then he will suffer the consequences, and such special precaution to be taken by the banker we will discuss as far as now is concerned. Okay, there are let us discuss very briefly refer to the general precautions in respect of opening and operating the account in the name of general customers. See, when an account is opened, just we have finished. A customer is a person who has some. A customer is a person who has opened an account with the bank. A customer is one who has an account with the bank is known as. A customer is a person who has an account with the bank. That is enough. Duration of that account operation is not required for a person to be called as a account holder or customer. So now, how will you open the account in respect of a general customer? How will you open the account? Normally, when an individual comes to the bank seeking an account opening, then the banker will inquire many things. He will give the account opening form. What type of account that is required to you, and what are you? He will inquire about you. These precautions generally banker need to. He cannot open an account without knowing your identity. Know your customer is a requirement today. Therefore, and just because you are individual, therefore you want an account to be opened, they will simply blindly will not open the account. They will insist on some requirement to be complied with. So he will require you, all the document to be furnished, like ID proof, address proof, photos, specimen signature, okay, ID, again introduction, okay, deposit, minimum deposit, anything else? Introduction is nothing but reference. Who can be introducer? You must be introduced. Generally, when in the account opening form, we are introduced by other customers, or we are introduced. If any one of the banking official is known to me, then he will sign. He is an introducer. The introducer is not a guarantee, but introduction is given by a person who is known to the banker. Remember, therefore, already existing customer could be the introducer. No problem. Okay, you should give the ID proof. You are, yes, but how will I know? Therefore, give your driving license, your voter ID, your Aadhaar card, something like that. Okay. Then address proof, Aadhaar card will do. Then your what is that called? Photos. Recent photos you must submit. And as far as the date of birth is concerned, matriculation certificate. Okay. Matriculation certificate to be your mass card. Then what is that? Photos. Then specimen signatures. 5. Okay. Sorry. A specimen signature card will be given, wherein you are expected to sign. Maybe there are 5 signatures in all. Okay. And a declaration form. That I will abide by the terms and conditions. No. And then introduction. And then the minimum deposit. And then declaration form to be signed. And when this is done, if the banker finds, all these requirements, banker simply cannot deny. But when these procedures, when in the account opening form, when an account is desired by the individual, account opening form is given. And then in that account opening form, so many columns will be there. You have to write your name, date of birth, then minimum deposit, which type of account, whether you are individual, joint, family, something you have to pick, whether male or female, everything. But all that you will fill, with the proof. What is that? Regarding ID proof, you have to give document. Regarding address proof, you have to give document. Regarding the photo, you have to give photos. Regarding specimen signature, you have to do that. Okay. Regarding your introduction, it has to be done by the person who is known to the banker. Normally, it will be banking official. if he knows you or any other customer if the banker knows, he could be the introducer, then introducer also should sign regarding minimum deposit standing currently, and then declaration form to be signed by him. When this is done, account is opened. These are the precautions. Banker should ensure that it is KYC compliance. Know your customer, compliance is done. Account is opened. General precautions generally these are the precautions to be taken in respect of general customers. An individual coming to open an account, yes. But there are some special customers. They are not like general customers. There are some special customers who, because of their status, may be minor. There are, however, persons whose capacity to enter into contract is subject to certain legal restrictions, and they are called, in view of their capacity to enter into contract, since it is subjected to some legal disabilities or restrictions, that is why we are calling it as calling them as a special type of customers. While opening and operating the account in respect of those banker, you have to be extra careful. I say that you are already careful while opening the account in respect of general customers, but in respect to these special class of customers who are subjected to certain legal disabilities, who are subjected to some restrictions, legal restrictions, you have to be extra cautious. You have to be very careful, extra careful while opening the account. Sorry, not only opening but also operating the account. These days banker will be very careful not only while opening but also while operating the account. You know why? It is for his own protection as well as for the protection of a customer is concerned. Now let us refer to those extra precautions to be taken by the banker. All these precautions you take, but extra precautions to be taken in respect of special type of customers. One is minor. The first precaution to say, don't open the account in the name, don't allow an account to be opened in the name of a minor who is under 18 years of age. Who is minor? A minor is a person who has not completed the age of 18. Therefore, it is advisable for the banker not to open the account in the name of minor. If you want to open the account in the name of minor, ensure that he is 12 years plus. He has completed the age of 12 years. When a minor completes the age of 12 years, he has by then attained the age of some discretion. That is why it is stated. So don't open the account in the name of minor is general advice. Want to open the account, ensure that he has completed the age of 12. And don't open the current account, as current account has got the overdraft facility, Therefore, in case if it is likely overdrawn, you cannot make minor personally liable for that. Therefore, it is better advisable. In case if you are still insisting on account opening, then insist like either account can be opened in the name of minor or account can be opened in the name of guardian and minor, joint names, or an account can be opened in the name of guardian for the minor. Okay, so therefore a banker can open a savings account, not current account, in the name of minor, either in the name of the minor himself or in the joint names of minor and guardian, or in the name of a guardian for the minor, right? And when the banker opens an account in the name of minor or in the joint name of minor or guardian, he should take the following precautions. What are they? It says, see that 12 years completed. If not attained, banker should not open the account. Who? Not the guardian, but the minor. Guardian should be a major, always remember, okay? Then he should make sure that minor is able to read and write English and regional language. If not, then don't open the account. He should allow the minor to operate his account as long as there is credit balance. Because only when there is a credit balance in the account, allow the minor to operate. Because under section 26 of NI Act, Negotiable Instruments Act, a minor can draw, endorse, deliver and negotiate a negotiable instrument. Under section 26 of the Negotiable Instruments Act, a minor can draw, endorse, deliver or negotiate a negotiable instrument. Therefore, allow him to operate when an account is opened, allow him to operate only when there is a credit balance. Okay. Since a minor cannot be sued personally for any liability, banker should not grant any loan or advance to the minor. Since a minor cannot be personally sued or be made liable personally for any liability, banker, it is better advisable, don't grant the loan or advance to the minor. If the banker, however, can grant the loans or advances to a minor on the basis of, a banker can, however, grant loans or advances to a minor customer only for the basic necessities of the minor. Okay, it is advisable when loan is granted for its basic necessities. It is advisable if the banker is to grant the loans for a basic necessity of customer, then he can grant the loan to the minor customer for basic necessities. There too, on the faith of, on the security of some personal property of the minor. You understand? And not any other. If minor has no property, then better don't grant the loan to the minor as such. Then the banker should never permit the minor customer to overdraw the account, as he cannot recover it because personal liability will not be there. Okay. Then what is that? It is always advisable to the banker to open the minor's account in the name of his natural guardian. It is like open the account in the name of X, the natural guardian, for Y, the minor. Okay, that way. Okay. Then banker should obtain the specimen signature of the guardian who is to operate the account. Right. Then he should take the birth date of the minor in the account opening form. Banker should obtain the specimen signature of erstwhile minor when he becomes the major. You understand? It was an account for the minor, and when the minor turns the major, banker should take the specimen signature of the person. Specimen signature of the erstwhile minor who has now become a major. So upon becoming a minor becoming a major, at this time banker should get the specimen signature of the major if he wants that account to be continued, otherwise not required. Okay. In case if the minor dies or guardian dies, what will be the consequence of the account? In case if the minor dies, money will be paid to the guardian. In case if the guardian dies before the minor becomes a major, then the minor, upon attaining majority, it will be paid to him. Okay. In case if the minor dies, amount will be paid immediately, account will be closed to the guardian. In case if the guardian dies, then minor will be paid with the amount only when the minor attains the age of in case if the guardian dies, then minor will not be paid the amount during his minority, but it will be paid to him when he attains the age of majority. Whether minor as minor as a partner, a minor cannot be a partner in the firm. But if all the partners can agree, minor can be admitted to the benefits of the firm, as you know, under section 30 of Partnership Act. When he is admitted to the benefits of the firm, he is not included as a partner as such. He will have to give a public notice upon attaining majority if he doesn't want to become a partner, because he's been there as a beneficiary since he is admitted by the other partners. But when he attains the majority, he should give a public notice if he doesn't want to become a partner. But if he doesn't give the public notice, it is implied that he has consented to become a partner, like that. Okay. Therefore, a minor admitted to the benefit of the firm can exercise its option to become a full-fledged partner, as I said. And if he chooses to become a full-fledged partner, then he will be liable for all the debts of the firm, which are incurred from the date he was admitted to the benefit of the firm as such. If he repudiates and severs his relations upon becoming major, then he will not be liable for the debts of the firm, provided he gives up a public notice, as I said, to that. If a minor upon majority who is admitted to the benefits of the firm, if a minor upon attaining majority, if he wishes to become a full-fledged partner, then he will be liable for all the debts of the firm. From what date? Not from the date on which he has become major, but from the date on which he was admitted to the benefits of the firm. But if he doesn't want to become a partner, then he should give a public notice and he will not be liable for the debts of the firm as such. Okay, right. Now, in the case of a married woman, as I said, in the case of a minor, you want to open the account, banker, if you know him, open in his own name, or better in the name of guardian for the minor. That will be always better. Then we have seen 12 years, no overdraft, no current account can be opened, don't grant loan because you cannot recover. If you want to grant loan, ensure that you have sufficient property to bind it. And we have also seen that banker should not discount a check or bill signed by the minor as such. All these. Then in the case of married woman, whether account can be opened in the name of married woman? Yeah, definitely. A married woman, like a man or unmarried woman, is competent to enter into a contract. Therefore, a married woman enjoys the same contractual capacity as a man or unmarried woman. She can acquire or sell her property, it is said. She can also open the account and operate that. Therefore, banker, safely you may open the account in the name of married woman, but the married woman is entitled to draw, to endorse, and banker can make payment for her checks and debit her account as such. The banker runs no risk at all as long as the married woman's account shows credit balance. Even if the banker grants overdraft or advance to the married woman, he runs no risk if she has sufficient personal property which she can dispose of and settle the account with the banker. So you must be knowing. But this comes when generally married woman, banker can open. Banker can allow its operation as long as it shows credit balance. He can also grant loan when she has personal property in her name on that security, right? However, banker runs risk when she has a personal property and it can be based as a security, banker runs no risk, he can grant the loan. But banker inviting risk when he grants an overdraft or advance to married woman who has no personal property in her name. Then how will you bind? Banker runs the risk while granting the loan or advance to married woman who has no personal property, or if the personal property is settled upon her in such a way that she should use only the income from that property which it actually falls due. Understand? 1 minute. So, while opening and operating the account in the name of a married woman, a banker runs no risk when married woman has got personal property in her name. And as I said, banker can always allow her to operate the account when there shows credit balance. Even loan can be granted when personal property is there. But when she doesn't have any property, movable or immovable in her name, to which she is not entitled, then whether you will grant overdraft or advance to married woman, and if you do so, don't you think you are inviting some sort of risk? Yes. 1, 2. Whether married woman cannot by her dealings bind her husband. Married woman cannot, by her dealings, she cannot bind her husband. The debts incurred by her are not binding on her husband. Remember, unless, this is important, a married woman cannot bind by her cannot bind her husband. A debt incurred by her, she cannot make her husband liable for the same unless those debts have been borrowed by her for meeting her basic necessity. Remember, unless they are raised for her basic necessities. In case if the debts are raised by her for the supply of basic necessities for her or for her family, in case if the husband makes a default in supplying that necessity, then she can bind her husband liable. Remember. But otherwise, if the debts are raised by her with the consent or authority of the husband, yes. If the debts are raised by her for the basic necessity of her or that family, her family, yes. When the husband commits a default, yes. When I said, she can however bind her husband in the following 2 exceptional cases. Generally, she cannot. Generally, the debts incurred by her are not binding upon the husband unless they are raised with the consent of the husband. Remember, in such a case, she would act as an agent of her husband. If she has incurred a debt, in other words, if she has incurred, debts are incurred by her are not binding on the husband unless they are borrowed with the consent of husband, in which case she would act as the agent of husband. Remember, she can, however, bind her husband in the following two cases. When she has borrowed the loan with the consent of the husband. Two, when she has borrowed the loan, when the debts are incurred by her, raised by her, if it is intended for her basic necessities, for herself or that of her family, when the husband has committed in providing for those basic necessities, she can definitely bind her husband liable. Otherwise, the husband shall not be liable for the debts taken by the wife in any other circumstances. In such circumstances, creditor has to recover the debts all from her personal property, and not at all the husband or his property could be made liable. That is what the risk. So therefore, in case of a married woman, special precaution that she has some property in her name. Then in which case a debt could be granted, because normally a debt cannot be taken, a loan cannot be raised by married woman without the consent of a husband. Or debt could be raised by her if it is meant for her basic necessities or that of her family, even the husband commits default. Otherwise, when she doesn't have property in her name, don't grant loan to married woman. Understand? If you want to grant loan to married woman, ensure that consent is of the husband is there. Or when you are still granting, though consent is not there, but husband defaulted in providing for the basic necessities, you can. Because when the married woman borrows for her basic necessity, even without being consented, when the husband commits default, then she can bind husband liable for the same. She can bind her husband liable for the same when the default is committed 100%, because it is husband's duty to take care of his wife for basic necessities as such. Then regarding parda, therefore the precaution is that, as I said, since a married woman is competent to contract, a banker need not hesitate to open the account. While granting the loans, I said take these precautions, right? And as far as a parda woman is concerned, parda nasin woman, what is that parda nasin woman? Who wears a parda or a will, who observes a complete seclusion from the public according to the nature of her custom or community. So she does not deal with the people other than members of her own family. Parda woman, I am talking about parda woman. A parda nasin woman is a woman who wears a parda or a veil and observes a complete seclusion from the society in accordance with the custom or tradition of her community. So she does not deal with the public other than the members of her own family. As she remains completely secluded from the members of the public, a presumption exists that any contract entered into by her might have been subjected to undue influence. Or the same might not have been made with her free will and full understanding of the consequences of the contract. Therefore, a contract entered into by a parda woman is not free from all defects. The burden of proof that contract entered into with a parda was free from above stated defects lies upon the other party in order to enforce the same. It lies upon the party who pleads that, no sir, we have not used any force or coercion or undue influence, etc. She might plead that, sir, this contract has been entered into without my free will. Then the burden of proof will shift on the other party. Other party will have to prove that they have not at all used undue influence or force as such. So that is there. That is the protection, because she wears parda. She is allowed to plead that since she is going by this custom, she did not understand fully well. She did not know the consequence of the contract, and therefore it is not executed with her free will as such. Therefore it is not free from defects. It's void. She may plead. And it refers even to the banker. Therefore, banker, while dealing with the parda woman, please beware that a banker has to take certain precautions before opening and operating before opening an account in the name of Parda woman. What is that? One, he should clearly explain to her the implications and the conditions attached to the account. Banker, while before opening the account in the name of Parda Nasin woman, you should clearly explain to her about the features of account, about implications in the operation of account, about the conditions attached to the account to be opened in her name, etc. And he should get her as attestation. He should get her attestation on the account opening form to the effect that she has completely understood the implications and conditions. Okay? You should take that declaration to be signed by her and it should be attested by her, right? And then he should see that the application for opening form, account opening form, is duly signed by her in the presence of a responsible witness. He should ensure not only account opening form, not only explained to him, not only that she should be attesting to the fact that account opening form she has clearly understood the implications and conditions, but also banker should get her account opening form duly signed by her. Duly signed, account opening form should be duly signed by her in the presence of a responsible witness. And third one, the withdrawals by her. I mean, in other words, we can say that Parda Nasin woman, whenever she comes to operate the account, she should always ensure that her operations are attested by responsible witness every time. Understand? Since the identity of Parda woman is not possible, the banker usually refuses to open the account in the name of Parda Nasin woman. Otherwise, it will be always inconvenience for that witnesses. That responsible witness who has to be there every time whenever she comes to operate the account. In case if he doesn't come, the responsible witness, he or she, it need not be of the same community. Okay, if the responsible witness doesn't come for even during the operation time, then it is better, the account operations can't be allowed. Therefore, it is said, since she observes Parda, it is better not advisable to open the account in the name of such woman, excepting according to the procedure as I stated. Then, in the case of drunkards, correct? In the case of drunkard, the banker should follow the following precautions. One, he should not open the account in the name of a person who is fully drunken. First, a banker should not open the account in the name of a person who is fully drunken. Two, banker should not deal with a person who is fully drunken in any way and should not get any document executed by the drunkard person. Okay, so don't open, don't get any document executed by him, and it is advisable for the banker to take the signature of some witnesses when he is required to deal with him and execute. See, banker has already opened the banker has already opened the account in the name of me, right? When in my name an account is opened, at the time of opening I was not at all drunkard, but subsequent to that I became drunkard, habitually drunkard. Oh, whether this account, no, banker should not allow its operation when the banker knows that I am drunkard. When I am drunkard, when I am in that state of affair, then it may not be possible for me to know I will not have a control over my mind only. Therefore, it should not be allowed to be operated as it is said. Then, therefore, it is advisable for the banker to take signature of some witnesses when he is required to deal with the drunkard person to execute some document. This is the precaution as such. So, a drunkard person is one who is intoxicated and that is incapable of understanding the nature and effect of the contract upon his interest, right? Therefore, banker, you should not open an account in the name of a person whom you know that he is a drunkard. It is better not to open. But the problem happens if an account is already opened without knowing that he is drunkard, or subsequent to the account opening if he becomes drunkard. Then you should not allow it to be operated without responsible witness, as I said. Illiterate person. In case of illiterate person, what are the precautions that you need to observe? In case of illiterate person, Mr. Banker, you are bound to observe these many precautions. An illiterate person, he doesn't know how to read and write, is it not? An illiterate person does not know reading and writing. He can enter into contract, no, though, but he does, he does not suffer from any other disability. No, he is unable to read and write, but he can enter into contract if he is at 18 plus, right? But a banker has to face still certain difficulties while dealing with an illiterate person when an account is opened. Therefore, it is advisable for the banker while opening and allowing its operation, he should take the following precautions. What is that precaution? Precaution number 1. As the illiterate person cannot sign his name, the banker should take the thumb impression of the illiterate person in the account opening form. As the illiterate person is illiterate, he cannot read and write. Therefore, he can understand whatever whenever it is explained to him. Therefore, since he cannot sign the name, therefore you should ensure that a thumb impression of the illiterate person is taken to the account opening form in the presence of two witnesses. In the presence of two witnesses, who should attest the thumb impression of the customer. 1. These two witnesses should also be known to the banker as such. Remember, these two witnesses should also be known to the banker as well as the customer. Remember, this is the first precaution. Second precaution, the banker should banker should also obtain the recent photograph of this illiterate person, customer, and the same recent photograph should be attested by those two witnesses. And those two witnesses should be attesting his thumb impression on the account opening form as well. This photo will help the banker to identify the customer whenever he comes for operations of withdrawal or whatever. Third one, the banker should see that an illiterate customer should attend personally. The banker should see that an illiterate person should attend personally since after the account is opened in the name of a customer. Since after the account is opened in the name of the customer, that's what I am telling you, illiterate customer. You should observe those precautions. Illiterate customer, he cannot read and write, correct? An illiterate customer cannot read and write. Therefore, since he cannot sign his name, get his thumb impression in the account opening form. Get the thumb impression duly attested by two witnesses, and those two witnesses should be known to the banker as well as the customer. Second one, what it says, second one, the banker should also obtain the recent photograph of illiterate person, and in the account opening form, that illiterate person thumb impression should be attested duly attested by the witnesses. You understand that? And the photo will help the banker to identify the illiterate person any time during the withdrawals. 3. The banker should see that the illiterate person personally coming to the bank for any operations, and affix his thumb impression in the presence of the official of the bank for the purpose of identification. Affix his thumb impression. He should come in person for any withdrawals, any operations, and affix his thumb impression in the presence of the banking official for the identification purpose. Right? This is what the precaution generally a banker is bound to take in respect of the illiterate customer. As far as the agent is concerned, see, right now we will proceed to, these we have finished. Agent, partnership, joint stock company. Since you have dealt with, who is an agent? An agent is a person who is employed by another to deal. An agent is a person who is employed by another in that another is dealing with the third parties. You understand that? Who is an agent? An agent is a person employed by the another as far as the definition of agency is concerned. An agent is a person who is employed by the principal, that another means the principal. An agent is a person who is employed by the principal to enter into a contract with the third parties on behalf of the principal. So he is a link to procure a contract between principal and third party, correct? It is possible. An agent is a person who is employed by another to deal with the third parties on behalf of that another. This is what I just wanted to recollect. An agent is a person who is employed by another to deal with that another on behalf of an agent is a person who is employed by another to deal with the third parties on behalf of that another. You understand? Therefore, is a link to procure the contract for the principal with the third parties. Right? Normally, for the work, agent will be paid either remuneration or the commission. Okay? There are different classification of agent also. What is that? Express agent, implied agent, delegated agent, sub-agent, substitute agent, agency by necessity, agency by holding out, so many. Okay? Agency by ratification, agency by holding out, agency by necessity, sub-agent, substituted agent, delegated agent, express agent, implied agent, factor, broker, mercantile agent. So many agents will be there. Even a banker is an agent, remember. When he is instructed by the customer to do certain things, maybe selling or buying the security and all. That's what it is said. When agent is appointed, it is said an agent is a person to be appointed as an agent should be capable of entering into contract. An agent is a person who acts for and on behalf of another person, and that another person is called principal. Now, what are the precautions to be taken by the banker while opening an account in the name of an agent? An agent performs such acts as have been expressly or impliedly authorized by the principal. Now, you know what is agent, and in the law of agency that you dealt with under contract 2, you have seen meaning of agency, features of agency, types of agent, the implied authority of the agent, and the liability of the agent, plus lastly you have seen when the agency gets terminated by the act of the parties, by the operation of law. By the act of the parties, by renunciation, agent renouncing, by principal revoking the authority. And from the time of revocation only, agent will not be entitled. But up to the time of revocation of the authority, whatever work has done, agent is bound to be remunerated. That is there, right? Thus the features of agency as such. Now, what are the precautions to be taken by the banker while opening and operating account in the name of the agent? I'll tell one by one. Please, listen carefully. Before allowing the agent to operate the account of the principal, the banker should require the power of attorney or letter of authority executed by the principal in favor of the agent. I know. Agent is a person who is appointed by the principal to conduct the business on his behalf. Correct? That is there. But here is the case. Whether agent can be operating the account which are in the name of principal. You understand? In the personal name of the agent, you can always open the account. No precaution needed. General precautions enough. But this is the case. Account in the name of the principal, whether agent can be allowed to operate. Right? Precautions. Account in the name of principal, whether it can be allowed to be operated by the agent. These are the precautions. 1. Before allowing the agent to operate the account of the principal, the banker should inquire, a banker should require and inspect, examine the power of attorney or letter of authority executed by the principal on agent in favor of his agent. The banker should closely go through that letter of authority or power of attorney to ascertain the extent of the agent's power. He should carefully examine that power of attorney or that letter of authority in order to ascertain for himself what is that exactly the agent's power. 2. The banker should see that agent always acts within the intravirus, not ultravirus. The agent must act within the scope of the authority. If the agent goes beyond the authority, then principal cannot be held responsible. Remember, therefore, banker should ensure that agent always acts within the power given to him by the principal, and within that power, he should deal with the operation of the account, and he cannot, go beyond the scope of the powers granted to the agent as such. Okay. 3. Banker should honor the customer checks. Banker should honor the checks, drawn by the agent, provided he signs in his capacity as agent, disclosing the name of the principal for whom he acts. In case the checks have been executed by the agent, banker is bound to honor those checks drawn by the agent, provided he signs in his capacity as agent for the principal. If he has signed, but not on behalf of the principal, if he has not expressed that he has signed in his capacity as agent for the principal, a banker should refuse to honor such checks signed by the principal as such. The question is that whether an account can be opened in the name of the agent, it is not the question before us. What is the question before us? Whether an account can be operated by the agent, an account to the principal. Remember, an account to the principal. The relationship is agent and principal. Whether the account of the principal can be operated by the agent. That is what being answered now. What are the precautions to be taken by the banker while operating the account to the principal by the agent? Then banker should procure one, the power of attorney or letter of authority executed by the principal in favor of the agent. And he should carefully examine that letter of authority or power of attorney. Second one, banker should always ensure, he should examine that Mr. Agent always acts within the scope of the authority. And the third one, it is stated, banker should honor the checks, okay, drawn by the agent, provided he means agent signs in his capacity as agent, disclosing the name of the principal for whom he acts or whom he represents. If he simply signs without mentioning the name of the principal, then such checks issued by the agent, signed by the agent, need not be honored by the banker. Banker can also grant loans or advances to the agent, provided the agent is permitted by the principal under the letter of authority or power of attorney. Okay, otherwise the banker should not grant. If in the letter of authority, if in the power of attorney executed in favor of the agent, if the agent is provided with the power to borrow the loan or advance, then he can grant. Otherwise, don't grant. Banker should see that letter of authority mentions separately agent's power to borrow. Okay, right. Then we will proceed to the another one, that is in case of partnership. Okay. As you know, in case of partnership, what are the precautions to be taken? I'll make one by one very quickly. You know the meaning of partnership. What is the meaning of partnership under Partnership Act? It is an agreement between two or more persons who have agreed to carry on the business, carried on by all or by anyone for all. A partnership is an agreement between two or more persons who have agreed to carry on the business to be carried on by all or one acting for all. You understand? To be carried on by all or by one on behalf of all. That is what? An agreement between two or more persons who have agreed to carry on the business to be carried on by all or to be carried on by one for all. This is what the meaning of partnership. What are the features of partnership? Three features essentially. Namely, an agreement. When we deal with the agreement, it is agreement capable of being a contract, because that agreement fulfills all the essential requirements to be a lawful agreement, to be enforceable agreement. Okay. 2, agreement must be to carry on the business, and every one of us knows agreement to carry business of profits. It implies even when they have agreed to carry on the business, incidental losses may also be part and parcel of the business. And third one, mutual agency shall prevail. What is that mutual agency? Each partner is the agent of the firm. You understand? Each partner is the agent of the firm and agent of other partners. Because I am allowed to act on behalf of other partners. That sense of mutual agency. Every partners are the agents of the firm. Each partner is the agent of other partners as well. That element or feature of mutual agency should prevail. Now, when banker you are aware this partnership, then you should know, while opening an account which is opened in the name of the firm, precautions to be taken by the banker are, yes, banker should carefully verify the partnership deed. As you know, partnership deed need not be registered. Even if it is unregistered deed, he should carefully know the partnership deed to acquaint himself with the partnership agreement as such and their business. He should examine the rights. He should examine their powers, liabilities, Okay. He should see that minimum number of partners are 2, maximum could be 10 in the case of banking and 20 in any other case. All. I think you have to have the knowledge. And whether minor can be a partner, this also you need to know. A minor cannot be a partner but could be admitted to the benefits of the firm. This also you have the knowledge. Therefore, have the knowledge. Banker should note that the date of the birth of such a minor partner who is admitted to the benefit of the firm, he should also know this. Okay. 2. Therefore, banker should very carefully examine the partnership deed so as to be acquainted with all these. 2. Banker, if there is no partnership deed, it is advisable for the banker to obtain a partnership letter duly signed by all the partner, coming to the bank and signing in the presence of the banker. If there is no partnership deed, I said, a partnership letter should be executed and should be signed in the presence of the banker by all the partners. Remember, right? And the banker can open the account in the name of the firm only on the receipt of the application. When 2 you have done, whether an account could be opened in the name of the firm. Yeah, when an application has been received from the partners with the request of opening an account in the name of the firm. So, okay. Then generally banks insist that all the partners should be present at the time of opening the account. Therefore, account opening form must be signed by all the partners. 2, 3 item. And 4th one, it is said, in the case, though all partner has got implied authority to operate the bank account of the firm, generally banker will insist that which particular partner or partners are authorized to operate it. Therefore, it is advisable for the banker to obtain a mandate. You understand? There are about, 2 minimum partners, it could be 10 or, 20 partners. It is advisable for the banker to, get a mandate from all partners regarding this partner or these 2 partners or these 3 partners are, authorized to operate the account. Then only those partners should operate. And if it is any other partner not authorized in a mandate, they cannot be allowed. And in fact, a banker should not allow them to operate the account, right? When you also know under what circumstances a firm will come to an end. A firm will be dissolved when there happens death of the partner, when there happens insolvency of the partner, when any of the partner is expelled, when any other partner becomes insolvent, when a new partner is admitted to the firm. Okay. A new partner is admitted to the firm, partnership will not be dissolved. Partnership may have to be rearranged. But in the case of death of the partner, insolvency of the partner, expulsion of the partner, or when the partner retires, any of the partner retires, expelled, died, or when he becomes insolvent. In these cases, it is a ground for compulsory dissolution of a firm unless the agreement otherwise provides. Unless the agreement otherwise provides. What is that agreement otherwise provides? If you have entered into an agreement of partnership, even during the time of agreement itself, you have clearly stated that the others cannot be made liable. A partnership can allow to continue subject to no partners, heirs could be made liable for subsequent transactions. Then it can be. But otherwise, it is a ground. If such agreement to continue the firm is not entered into in time, if any of the event happens, then firm will come to an end. In other words, what I mean to say that you should carefully go through the agreement. If there is a clause like this, in spite of this, the partnership firm will continue to exist by rearrangement, then okay. But otherwise, if there is no clause to save the firm in times of those, then when the banker gets information that a partner has become insolvent or expelled or retires or died, then immediately he should suspend the partnership account as such, its operation. Okay. It is also possible sometimes when if the authority of not all the partners are authorized to operate the account. When the authority of the partner is revoked by the other partners, then banker can continue to operate the account banker continue to allow the operations by those partners unless in which case the other partners cannot make the banker liable unless the other partners revoking the authority of the partners allowed to operate hitherto. If they have revoked, the other partners are bound to inform that fact to the banker. When informed, banker should suspend the operation from those partners. Okay, so therefore you should be bound by it. Okay, then in case whether a partner can this is very important as such, whether a partner who is allowed to operate or partners allowed to operate, can they borrow money? Can they borrow money for the partnership business? Oh, 100%. They exercise the borrowing power. They can borrow the money for partnership business, provided all partners have authorized. All partners should sign that this partner is authorized to borrow. Understand? Otherwise, he should not, because banker will not lend without the security. And whether partnership property could be pledged, partnership movable property could be mortgaged for the purpose of borrowing loan. Generally, it is not possible unless the partner or partners pledging or mortgaging has got the authority given to them by all other partners. Remember. Then there is one more case that is equally important. As far as the borrowing is concerned, banker should not allow the partner or partners authorized to operate banker should not allow to borrow loans or advances on the security of partnership firms property, movable or immovable, unless every partner have signed the document creating the pledge. Therefore, banker should insist that all the partners should sign the document creating the pledge, or document creating the mortgage as such. Okay, and there is one more. What is that called? That is equally important. And it has come to my mind and suddenly disappeared. It's regarding whether banker while allowing its operations, partnership operations, banker should ensure that a partner authorized to operate the account will not deal partnership account with its own. In other words, whenever a partner authorized to operate the account, banker should ensure that whether it is the check issued to the firm's account or to his personal account. It means to say that a banker should not allow a partner authorized to operate to deposit a firm's account check. To deposit a check to firm's account. A banker should ensure that a partner is not dealing with the firm's account. Partner is not a partner authorized to operate the account is not dealing with the checks of the firm with his own personal account. It is possible sometimes a deceptive partner may deposit a firm's account, may deposit a check issued to firm's account to his own account. So banker, whenever a particular partner authorized to operate the account, whenever he deposits any check to his own account, personal account, banker should verify whether this check is meant to his personal account or this check is meant to firm's account. If it is meant to firm's account, he should not allow it to be. Okay, right. When a partner is expelled, then banker should disallow that partner to continue with the operating of this particular agreement, this particular operations as such. Okay, therefore these precautions must be taken, but these precautions could be taken only when the banker is acquainted with the laws relating to partnership. Plus, only it is possible when he knows what exactly partnership partners have come to open an account. But then you should ensure that what is their partnership agreement. If there is no partnership agreement, at least partnership letter, you should ensure, you should get it to examine how many partners are there, whether it is as per the law, what are the rights and liabilities of partners, and when you know that, how many partners are there? There are 8. Then who will open the account in the name of the firm? Who are authorized to operate the account in the name of the firm? Whether they can exercise the borrowing powers? Can they deal with their own personal account? Can they deal firm's account to their own personal benefits. All these banker, you should be extremely cautious, and any time whether any borrowing power is exercised by any partner, it should be ensured that all partners will come and execute that document. That document creating pledge, document creating mortgage of firm's movable or immovable property, as the case may be. The precautions you should, similar precautions that you should follow in the case of joint stock company. While opening and operating, remember what is company? Company is an association person who have agreed to contribute money or money's worth to a common stock and then apply the said money, common stock, for the purpose of carrying on business. And an association person will become a company as per the provisions of company law. And the minimum number of persons in the case of public company is 7, maximum is unlimited. In the case of private company it is 2, maximum is 50. You should know so many provisions relating to you and the banks. He must be aware of the features of the public limited company, features of private limited company, and the borrowing powers, etc., etc., and their liability and all. Right? Whether an account could be opened in the name of the joint stock company? Yeah, definitely. An account can be opened. Which account is advisable? Preferably, it is a company, so a firm or a company, preferably it is advisable to open a current account. What precautions the banker may have to take? Yes, certificate of incorporation. Mr. Banker, you examine the certificate of incorporation. You examine the two public documents like a memorandum of association. You examine the memorandum of association will define the objectives of the company. Memorandum of association is having 6 clauses like name clause, registered office clause, liability clause, capital clause, association clause, and objective clause. Registered office clause, name clause, objective clause, liability clause, capital clause, and the association or subscription clause. In each of those clauses, specific things are clearly explained. Therefore, memorandum of association will, in case if anyone wants to deal with the company, then company could be better introduced to them by the memorandum of association. Memorandum of association therefore introduces the company to outsider. Whereas articles of association contains the rules of management, how the management business is to be carried on, what all the rules. You have given, as I told you, a trade union before registration should furnish a copy of the rules that is applicable to that trade union. Only upon the those rules trade union will be registered as such. But it is not the case in case of it is the same case in the case of company. So if you want your company to be registered, then you should submit these 2 documents, memorandum of association dealing with the objectives, therefore it is the chart of the company, and articles of association dealing with the rules of the company, rules of management. Memorandum controls the article, I can tell you. There cannot be articles of association drafted without referring to memorandum. You should examine. You understand? A statement to be obtained from the auditors. And the document should be certificate of incorporation to be furnished. Then memorandum of association. Then articles of association. Then the copy of a board's resolution. Remember, appointment of if a company, if a director, if an account is to be opened in the name of the company, a banker, apart from examining the certificate of incorporation, registration certificate, memorandum of association, articles of association, and besides your acquaintance with the company laws, Mr. Banker, you should also know that there should be a board resolution for appointing this bank as company's bank. You understand? What is that copy of? Where is that copy of the resolution of the board of directors appointing this particular bank as the company's bank? That has to be there. The names of the person or persons who are authorized to operate the account on behalf of the company, the directors. Whether all directors? No. It is a particular director or the particular directors who are authorized to operate the account on behalf of the company. Whether resolution has got any effect to that? Yes, it should be there. Then only it will allow such person to come and fill the forms and get the account open and in the name of the company, and it could be operated by them only. Then the name of the persons who are authorized to execute the documents or deposit the title of deeds on behalf of the company, it should be furnished. The name of the persons who are authorized to execute the documents or deposit of title deeds on behalf of the company or in whose presence the seal of the company will be affixed to all the documents. Next, the maximum limit up to which the company can borrow by the authorized person or see, if one or two directors are authorized by the company to operate the account, whether they are authorized to borrow, yes, state it. If they are authorized to borrow, then at what particular limit they are authorized to borrow, state it. At what particular limit they are authorized to borrow should also be stated by the by whom? By the said document. An undertaking to that effect that you have permitted one director or two directors to what is that, to exercise the borrowing powers. What amount could be borrowed by these directors who are authorized to operate the account? What amount could be borrowed in the exercise of the borrowing powers? That a specific limitation should be, and name of the person who are authorized to deposit the title deeds in the equitable mortgage. Yes, all these. Then the borrowing powers of the company. Whether company can exercise the borrowing powers, then how it could be borrowed. Could it be borrowed without the authority? And this has to be precaution to be taken by the banker while allowing the company to borrow, exercise the borrowing powers. One, the banker should ensure that company borrows the money only for management of the company, as specified in the Memorandum of Association and Articles of Association. The banker should ensure that company borrows the money only for the purposes as mentioned in the Memorandum of Association, and the banker should obtain the certified copy of the resolution passed by the Board of Directors. And thirdly, the banker should obtain a certified copy of the resolution passed by the Board of Directors, certifying that company borrowings, including the proposed borrowings, are within the limits specified under the Companies Act, or are within the limits approved in the general meeting, right? So, while allowing the company to exercise the borrowing powers, general precaution to be taken, the precaution to be taken by the banker for allowing such borrowings are the following. One, the banker should ensure that company borrows, authorized persons borrows on behalf of the company, for the purposes as contained in the memorandum. Two, that the banker should ensure, the banker should obtain the certified copy of the resolution of the Board of Directors. And also, the banker should also obtain a certified copy of the resolution of the Board of Directors, certifying that company borrowings for the purposes, etc., are within the limits authorized under the Companies Act. Understand? Okay. Then, the registration of charges under the Companies Act. Okay. Any charge for securing any debentures, etc. I said the banker should ensure that he will, what is that called? The power to borrow money also entitles the company to create a charge, power to registration of charges under the Companies Act. When the banker is lending to the company for the purposes as specified in the Memorandum of Association, and the banker should ensure that some interest is created, whether it is fixed interest or floating interest, is created in respect of any of the property. And whether that any of the property, whether charge could be created in respect of those property, then when the charge is created as a security interest in favor of the bank, then it should be registered. You understand? So, in respect of what all property a charge could be created, you should know, Mr. Banker, and you should ensure all those. And unless you follow these precautions, generally a banker grants secured loans on the basis of fixed charge on the fixed assets of the company and a floating charge over the movable assets of the company. You understand? Precaution to be taken by the banker in respect of those, in respect of the charge subject matter is concerned while borrowing, while allowing the borrowings. Bankers should grant secured loans on the basis of fixed assets of the company, and secured loan on the basis of fixed assets, and floating charge should be created over the movable assets of the company as such. Okay. Therefore, banker, while granting the loan on the basis of fixed or floating charges over the assets of the company, banker should find out whether there is any prior charge. As you know, law of property, Transfer of Property Act deals with that.